Greetings. This is coming directly from Carl Miller, right? So we are going to look at the Supremacy Clause of the Constitution. That is Article 6, Paragraph 2. Let's look into that. Article 6, Paragraph 2 says, "This Constitution and the laws of the United States, which shall be made in the pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding." Notwithstanding being a legal term, meaning doesn't apply. Okay, that means that the Constitution, is the supreme law of the land. And every law needs to be made in pursuance thereof. And anything that is in conflict with it, we are going to address right now with the case Marbury versus Madison, which was in 1803. The opinion was given from the Chief Justice of the Supreme Court in 1803 by Honorable Judge John Marshall. He said anything that is in conflict is null and void of law. Meaning clearly, he went on to say, for a secondary law to come in conflict with the supreme law was illogical, for certainly the supreme law would prevail over all other law, and certainly our forefathers had intended for that supreme law would be the basis for all law. For any law to come into conflict would be null and void of law, it would bear no power to enforce, it would bear no obligation to obey, for unconstitutionality would date from the enactment of such a law, not from the date so branded in an open court of law. Meaning, if somebody finds a law that's like, or an ordinance or a policy or a statute or something that is like, that's unconstitutional, brings it before a court, the court decides, yeah, you know what, that is unconstitutional. The unconstitutionality doesn't date from that point, it actually dates from the very point that the unconstitutional law, statute, policy, whatever ordinance was enacted in the first place. So in other words, no courts are bound to uphold such an unconstitutional, I'll just call it item instead of listing that list, and no citizens are bound to obey it. It operates as a mere nullity or a fiction of law. In other words, it means it doesn't exist in law. In my opinion, it is the citizen or the private American's duty to break all unconstitutional policies, statutes, ordinances, practices, laws, acts, what have you, publicly. It is our duty to do that because unconstitutionality has no bearing. There is no basis for it. Nobody has any obligation to obey it, and no court is bound to uphold it. It is our duty to rub the people who dared make such an unconstitutional mandate or etc. in the first place. Rub their nose in it. It's disgusting, right? Here's a couple of examples. Requiring that somebody has to register their private property in order to convey themselves from A to B. If you're not performing commerce on a roadway, guess what? That roadway is zoned for public use. And who has the right to use them? Everybody. You don't get to police it, just like it is a private easement. Okay, and the police don't get to decide that it's suddenly a private easement worthy of their policing, because they are administrative agents, and administrative agents are bound by the determinations and the standards set by legislation. So they can only abide by the standards that are already currently set. They do not have the power to determine a new standard upon which they're going to operate. That is the truth. We are actually free. Okay, and here's another one. If somebody claims that they don't have to have an oath of office in order to discharge governmental services because they weren't elected or appointed, there you go, there's another unconstitutional one. We need to start ignoring these things, acting boldly, being the people that God himself determined us to be. Thank you, my fellow Americans. Have a wonderful evening, and God bless all of you.